Hey, I'm Paul Rabelais, and in this video I want to talk about one of the two kinds of Louisiana succession. So I'm Paul Rabelais. I'm an estate planning attorney helping families around Louisiana get and keep their legal affairs in order. Successions confuse people. First, let's just start with the basics. In Louisiana, we call this court proceeding that occurs when somebody dies with assets in their name. We call it a succession. Other states call it a probate. So sometimes people here call it probate as well. So you could say probate, you could say succession, and people will know what you're talking about. So when it comes down to getting a succession done when somebody dies and they have assets in their name and those assets are frozen, there's really two kinds of successions. And I'm going to address one of those kinds in this video. The first kind of succession, the one that I'll address in this video, is the succession without an administration. And then the second kind of succession is the succession with an administration. You might be throwing your hands up in the air and saying, what's a succession? What's an administration? So I touched on it briefly earlier. A succession is that kind of court-supervised proceeding. It's just the way it is. When somebody dies with a home in their name or some investments, maybe vehicles, it's just the way it is. Our court system is set up to have to oversee the administration of it, the management of everything, and make sure it winds up going into the right people's hands. So what I want to go over in this video, though, is, and some of you may be saying, well, what's an administration? When, Paul, you're talking about in this video what a succession without an administration is, what's an administration? So an administration is a step in a succession when a judge who has been assigned by the clerk of court to oversee this court proceeding, when a judge either does what's called confirms the executor who was named in the will as the executor, the judge confirms that this person is in fact the executor. Or if there's no will, a judge will appoint an administrator to oversee the estate while all of this is going on. So that's not a step that occurs in every succession. In fact, in this video, we're going to talk about when it doesn't occur, because it doesn't always have to occur. I always like to use examples. Let's use an example before I really confuse you. Let's say Dad died and Dad had a will. And in his will, he said several things, but essentially Dad left his estate to Mom. And when everybody writes a will, they always name an executor. Dad named Mom as the executor. And Dad had relatively, few assets. So here's a situation, there's not going to be an administration because the person died. They had few assets and they had few heirs. Dad died, left his estate to Mom, named Mom as the executor. Dad's assets include a few things, kind of the normal things. Dad and Mom had their home that they had purchased, many years ago. Dad had an IRA, named Mom as the designated beneficiary. Dad and Mom had their joint bank accounts. They had their checking account at the bank, they had their savings account. And they had a couple of vehicles. And let's say one was in Dad's name and one was in Dad and Mom's name. Now, because Dad died and he didn't have any other kind of complicating factors in his estate, it was pretty simple. He left everything to Mom, and there were a few assets, though, that required that a succession take place. So let's go asset by asset. So yes, the house. Gotta do Dad's succession, because when Dad died, the house was entitled in the names of Dad and Mom. Mom can't ever sell that house until she does the succession, which will transfer Dad's half of the house into Mom's name, so Mom will own the entire house. Then she can sell it or leave it to others or whatever she wants to do with it. Now, with the Dad's IRA, no succession is necessary. Dad had named Mom as the designated beneficiary. Mom can grab the death certificate when she gets it, takes it to the financial institution. They'll move Dad's IRA into Mom's IRA. No lawyers, no judges, no court orders needed for that. Dad and Mom had some joint bank accounts, and the bank's allowing Mom to continue to write checks and access those funds. So Mom feels like, hey, I don't need a succession to get at the bank account. I've got access to all of it. But then they've got a couple of vehicles, and dad's name is on one title and dad and mom's name is on the other title and the one she drives. Mom can't sell or trade in any of those vehicles because dad's name is on the title. It's not an or thing. So the succession is going to be necessary to get the appropriate court orders that can be submitted to the Office of Motor Vehicles, so those titles can then be transferred solely into mom's name. So after dad died, mom's thinking, okay, I've got the IRA, I'm still on the bank accounts, I just need to get the house and the vehicles dealt with. So that's a scenario where we don't need to get an executor confirmed because mom's got access to all of the funds. There's little or no debt, and plus she's got access to all the funds anyway. Everything's going to her. She's not planning on selling the house or vehicles in the next couple of weeks. So we can simply do dad's succession without an administration, which essentially means we got to prepare a bunch of court paperwork, all these pleadings and petitions and descriptive lists of assets and debts, and get mom's and perhaps another family member's signature on some of those court pleadings. And then we file all that at the courthouse from the parish where dad lived. And essentially we're asking the court, and I always get a funny feeling when I say we're asking the court. We're really asking a judge who the clerk of court assigned to oversee this court proceeding. We're asking a judge to sign what's called a judgment of possession, which is a court order where a judge will order that anything that's in dad's name, and we will have a list of those assets, a judge will order that those assets be transferred into mom's name. And so we can get that court order recorded in the real estate records of the parish. That's what transfers the home from dad and mom's name to mom's name. We can get that court order to the Office of Motor Vehicles, and then they'll retitle the vehicles from dad's name or dad and mom's name just to mom's name. And again, she didn't need any of that to get the IRA and the joint bank accounts. She kind of likes the fact that his name is on the checks anyway, so she's not gonna change any of the bank accounts, so she doesn't need any kind of court order to continue dealing with her checking and her savings account. So in that scenario, we didn't have to go through the step of an administration. Few more points that I want to cover on this succession without administration video. One is, since we're talking about a succession without an administration, which typically is done when there are few assets and maybe just one, sometimes two heirs, probably worth mentioning the small succession affidavit procedure. And this is applicable when it bypasses the whole court-supervised process. And it makes it, there's an easier and quicker procedure that's done by affidavit, but it's only applicable when someone dies and they have no will and what they own is worth less than $125,000. I know a lot of bankers and I know a lot of people out there are just telling all of their customers, just do the small succession affidavit. And so they're misleading their customers when the bankers and other third parties aren't even inquiring whether the person who died had a will and whether they had other assets that may cause their estate to be over $125,000. Either one of those situations means that the Louisiana small succession affidavit procedure is not available. So, but when we mention, very small successions, probably really have to mention seeing if the Louisiana small succession affidavit procedure is available. And then the other scenario, which we'll get into in the other video, is just some of the terminology when there is an administration. Is it an executor? Is it an administrator? What's the difference? That'll be all explained in the other video. We'll touch on the independent administration, another area that confuses people. So my point here was there's two kinds of Louisiana successions. In this one, we addressed the succession without administration, when the estate is relatively free of debt, and probably best that you watch that other video to really see the difference between without an administration and with an administration. So, but I hope that gives you some guidance on kind of the beginnings of starting to understand some of this succession procedure stuff. Can be complicated to many, and especially when it's done at a difficult time when families are grieving. And so want to keep you informed. Okay, I'm Paul Rambolet. Have a great day. Oh, by the way, make sure you punch the subscribe button, hit the notification bell, and punch the big thumbs up like button. See ya.